It's the president's prerogative. The Constitution gave that power to the president based on the recommendation of the NJC. Once the NJC has done the recommendation, it rests on the president to take the recommendation or not take the recommendation. That is why it's simply a recommendation. So he will have to take his time if he wants to take his time. And we've seen how it has been. Everything had been running on a slow lane. It's not only the judicial sector. Every aspect of Nigeria has been on a slow lane. So that is the style of the president. But the bottom line is that the courts have come up with a method of how judges should be appointed. They do it in order of seniority so that there will be no rancor of any kind. The Supreme Court, being the last court, is inundated with too many cases. Today, if an appeal is entered in the Supreme Court today, 2020, going by the trend of what we have now, the earliest time that case can be taken would be 2033.
Wow.
Minimum of 13 years. I've had cases entered into 2007, 2009 that have not even seen the light of day.
What's causing the delay?
There are too many cases. And, okay, like for instance, in my office, we had 2 cases listed for hearing after so long. But when it was time for them to be heard, the courts cannot take those cases because they were attending to election petition cases. And the bar is arguing that we should at least inject fresh blood into the Supreme Court, get people from the bar, get people from the academia to come into, to inject fresh blood into it. But that position is not well taken by the judiciary, because they feel that why should they come and encourage into our territory when they are on another lane entirely? And it's really affecting the quality of the judgments we're having. Most of our judgments, there's no substantive law being determined. Everything seems to be procedural. We need landmark cases. We need precise position of the courts on substantive law. Let us develop our laws and everything. But now, just to me, it appears as if everything we do there is, okay, let's just do it, you know. But I think the president, maybe the vice president, being a lawyer himself, should understand the problem and bring it to the fore to enable the judicial system to be what it should be in all ramifications.
I'm glad that you talked about the vice president. Some other people too, rightly or wrongly, have also blamed the attorney general. He advises the president. How much of the blame do you think he should take for this delay that we are seeing in the appointments?
Well, I don't know. I don't know a lot about politics. I only know law. I know that in every circumstance, politics is what we're saying here. That is what is playing out. Because I know that the bar are advocating that, look, this time we must have other people coming in, and the judiciary wrestling is not going to happen. And even because the CJN had made public pronouncement relating to that, and in that regard, what can the Attorney General do? What can the Attorney General do? Don't forget that the CJN is the chairman of the Judicial Council, National Judicial Council, that will make recommendation to the president. So look, we're just in a quandary. We're just going round and round in circles. So unless and until we have fundamental changes, it's not very likely we will go far relating to this question of getting people appointed to the Supreme Court.
But you think that there is merit in that argument that lawyers from the bar should go to the bench?
Absolutely. Absolutely. Look, if we go back to history, the people that came from the bar, they did wonderfully well in the Supreme Court.
Let's talk about COVID-19 and some of the issues that come with it. Despite the lockdown, despite the global pandemic, we still have disputes which necessitate a recourse to the courts. And some people have made the argument that legal services, the courts should be essential services, and that the courts should remain open and work full steam. Do you think that there is any merit in that argument?
Oh, certainly. If you go to visit the police stations now, you see it filled to the brim. There was a day I went to Panti. There was no space to put people. They had to lock them in Danfo in front of the station. So, certainly, in other climes, legal services are considered to be essential. Even in Africa, it's considered to be essential. So why would Nigeria be different? And particularly because of the lockdown, it created so many social problems that the courts must quickly intervene. So we have to find a way to get the courts to be on in full steam. Yes, the courts are coming up, although the practice direction said you cannot take trials. It's only cases where judgment, final address, or affidavit evidence will be required. So in a situation where there is an urgent matter that you require to take evidence in court, we will not be able to do it. So that's why people are advocating for virtual hearing. Maybe if we get to virtual hearing, we may be able to make sure that the stream of justice continue to rule.
We'll come to virtual hearings, but I want to stick with the issue of legal services being considered essential services.
Clearly it is.
So
clearly.
Is it safe to open the courts fully?
Well, there are protocols. The NCDC has issued protocols that everybody must follow. Even my little office, we have to follow the protocol. You use your thermometer, you wash your hands, you use hand sanitizer.
So you think once all that is done, the courts should open fully?
Well, yes, and then they restrict the number of people that will come into courts to maintain social distancing. If your case is not on, you cannot enter the courtroom. I saw people sitting outside the courtroom today, even despite the rains, because it wasn't their turn to come into the courtroom. So there's a way we can walk around this.
Let's come now to the issue of virtual or remote court hearings. There have been arguments for and against. Some lawyers saying that the laws that we have in place now accommodate virtual court hearings. Some lawyers say no, we need to go back to the Constitution. So much so that even the lawmakers are trying to amend it. And some people say if you do that, then all that we've done would be rendered null and void. That so with the laws we have are adequate. There's no need to amend. Where do you stand on this argument?
Well, personally, I believe that the Constitution provides that court proceedings and delivery of judgment must be in public. The question is, what constitutes public?
Yes.
The argument, yes, is germane that, well, once you give out the link, anybody can come into the thing.
More than a courtroom can even accommodate.
That's the argument I've heard so many times. But personally, I would not go on with virtual court proceedings because I've been caught in the issue of what is considered to be public. I had a matter that emanated from the High Court in 2000.
20 years ago.
And got to the Supreme Court late last year. And the Supreme Court set aside the judgment of the High Court simply by the fact that the judgment was delivered in the judge's chambers, even though the judge wrote that this was the third day that he was unable to deliver the judgment because there was cuts in the public power supply, and the courts, the way it is in the Lagos High Court, you cannot see at all. So he was compelled to deliver this judgment in chambers. And we argued that because...
And lawyers had access to the chambers?
That's the thing. The parties were all in the chambers, and the doors were open, the windows were open, because there was even no light anyway. So you had to open the windows and you had to open the door. And our argument was that, look, the fact that, yes, naturally, the judge's chambers was not a public place, but for that purpose, it should be considered as public because the doors were left open. There was no light and we were so many. So even for ventilation, we needed the door to be opened and everything. But the Supreme Court said no. So you can imagine 20 years of work gone down the drain just because of the interpretation the Supreme Court had placed on the meaning of public. So I would not participate in any proceedings, virtual proceedings, without the amendment of the Constitution to reflect that public can include internet access and what have you, or howsoever they would want it amended. But because looking at the state of the law, Well, I'm eagerly waiting to hear what the Supreme Court will say on the Lagos State matter.
That has gone before them.
All the judgments that they have given have been very restrictive of the meaning of public. So we'll see what they say. Until they say so, I would not take any virtual hearing.
So if you get a date from the court that your matter is going to go
I'm going to raise an objection. Okay. So the court can rule, then we can continue to go on appeal on that. It's better to do that. Look at it now. The case I was talking about, the land case, most of the witnesses are dead. Where do you start from? And look, I don't even want to imagine starting afresh again. I mean, I cannot. Once bitten, twice shy. 20 years down the drain, I'm not ready to try it again. Because anybody who doesn't have anything to do, if you really don't have any substantive case and you just want to use technicality, that's the first thing you do. I mean, that was why we went to the Supreme Court. Even in that appeal, they didn't raise any substantive thing. It was just that judgment was delivered in chambers, it was unconstitutional. Set it aside. And they did.
Finally, I know you must be worried about the rising cases of sexual violence, rape cases, defilement that we've seen on the increase now. Some people say it's as a result of the pandemic. Some people say it was there before the pandemic, but now there's increase in reporting. But do you think that our laws are adequate to cater for the victim? Do we have enough laws to help the victim?
Well, that's a tough one.
Because more worrisome is the fact that even though there are so many cases, the rate of conviction is not the same.
It's not even only the rate of conviction, I would say. It's not only the rate of conviction. Even when the conviction comes, what punishment is meted out to the accused person? The law stipulates life imprisonment. Then you find judges given 3 years imprisonment.
Why do they do that?
Well, it's a society. It's the male chauvinism. What is rape? Do you understand? Going back, you will see that the attitude of the courts, I believe, is what had encouraged rape. If 5, 6, 10 people had been sentenced to life with hard labor, the other person would think twice. But when you give three years imprisonment and you give 7 years imprisonment, it's like you're just tapping their hand. Don't do
slap
it
on the wrist, yes.
Yeah, that's it. We're just joking. If the proper punishment is imposed, I guess that it should be a deterrent. Although sociologists will tell us that really does not deter. Punishment does not deter people, because everybody always believes that if I do it, I will get away with it. So it may not be, but at least it will make the victim feels a bit better that, okay, you are caught, you have to do life. But personally, I could see that there have been argument, people saying it should be death and what. There was one I read on the social media, a 3-month-old baby that was raped. I said, look, that man, for me, it should just be castrated. And the way the House of Rep turned that down with a wave of the hand made me to feel that because it's a male-oriented society, it doesn't concern them.